I'm Charles Kessler. Welcome to the American Mind. Hadley Arkes has been for 45 years, a professor of political science at Amherst College, and for 25 of those years, the Edward Ney Professor of Jurisprudence. He is the author of First Things, a classic articulation of the case for natural law, which volume grew out of a course he still teaches at Amherst on political obligations. It is, a particularly discriminating professor friend of mine remarked to me recently, the only book by a living author that she teaches. Mr. Arkes' most recent book is Constitutional Illusions and Anchoring Truths, published by Cambridge University Press. Also, I submit, a tome worthy of being taught, despite its author's disability of being alive. In addition to his scholarly achievements, Mr. Arkes is the principal architect of the legislative strategy that culminated in passage of the Born Infants Protection Act. Infants Protection Act, signed into law by President George W. Bush in 2002. This act, the greatest victory for the anti-abortion cause since Roe v. Wade, is in many ways Mr. Arkes' baby. His latest essay in the Claremont Review of Books in the fall 2001 issue is called A Natural Law Manifesto, the inaugural trumpet blast of the Claremont Institute's new Center for Natural Law Jurisprudence, of which he serves as director. Mr. Arkes, do the principal and most strenuous objections to natural law in our times come from the left or from the right?
Well, the deepest objections come from the left and the people denying that there are moral truths. But perhaps we ought to step back for just a moment to recall what the elementary case is for natural law or natural rights. With the American founders and Lincoln, we had the understanding that certain rights simply were drawn from the very nature of human beings, in the differences that would separate, as Aristotle had it, human beings from other animals. That animals could emit sounds to indicate pleasure or pain, but human beings could give reasons of the things that are right or wrong. And so the argument was that it is simply wrong to rule other human beings, horses and cows, in the way that we rule beings who can give and understand reasons. That would be wrong, therefore, to rule these beings without their consent. And the wrong then of slavery, of ruling human beings without their consent, would be the same wrong in every place where that nature remained the same and the distinction between animals and humans subsisted. So as we say, even in this age of animal rights, we don't find people signing labor contracts with their horses and cows. Or
not yet.
Giving yet. Or giving well, they may want to marry them, different places. Or seeking the informed consent of their household pets before they authorize surgery on them. But we continue to think that those beings who can give and understand reasons over matters of right and wrong deserve to be ruled with a rendering of reasons. So all of this is the origin, or the rudiments of it. We begin with the things deeply embedded in nature and draw the implications of that nature for politics. And of course, the understanding in Aristotle is that a political life, a life characterized by the making of laws, the imposing of laws, the framing of propositions, only one kind of creature can give rise to that kind of an arrangement. Only one kind of creature could understand what it means to respect a law beyond one's own appetites, or to respect the notion of a commitment or an obligation that remains valid even when it no longer accords with one's interests or inclinations. So Charles, you raised the question of where's the rejection? The deepest rejection, of course, would come from the people who insist that there are no moral truths. And certainly no moral truths that hold in all places. Remember, Lincoln said about Jefferson in the Declaration of Independence, all men are created equal, the only rightful government is that which draws its just powers for the consent of the governed. That Jefferson articulated at that moment an abstract truth applicable to all men and all times. Now, the deepest rejection comes from the left, denying that there are moral truths. And in fact, we find in the Academy
denying that there are any moral truths.
Any moral truths that hold, and certainly no moral truths that hold across cultures, as they say. In fact, what we get today in the doctrines of radical feminism and postmodernism is the insistence that what you call natural rights was simply a radical ideology to cover the rule of white men. And that what you call nature, they'd say, is simply socially constructed from one place to another according to the vagaries of the local culture. And of course, there are no moral truths. But the curious part about these people is that they think they can identify wrongs done to women in other cultures. In fact, they think they can identify women in other cultures.
Yes.
So you say in the curious world of the left on the campuses, there are human rights to be vindicated all over the globe, but strictly speaking, there are no humans, because there's no human nature.
Not to mention that the proposition that there are no truths or moral truths has itself to be true.
Yes.
Which is a bit of a complexity.
That's right. It's a contradiction that doesn't deter them
Yes.
in the course of their
It's what
their
Wilmer
yes.
Kendall used to call the Achilles heel of all relativism. That relativism itself has to be true, and so it can't quite be the case that everything is relative and nothing is true, right?
That's right. That's right. So it's the.
But what about so a sophisticated though objection seems to me would be perhaps to admit that there are these differences between species which seem unchanging and grave and meaningful. But if you think back to what Richard Hofstadter famously said, the historian Richard Hofstadter in the mid-20th century, that no one who now knows as much about natural science as the framers knew in the 18th century would any longer believe in an unchanging human nature. So maybe the difference between us and the other species is in some sense maybe not fixed, but barely changing, but we're changing. What it is to be human is somehow continually changing. That's the premise of some form of progressivism, right? That things are getting better, including us. Our nature is getting better. Does that disable natural law, if that's true?
Well, it reminds me of Churchill's line about the Bolsheviks, that they're crocodiles with master minds. You get a fusing of the two. I guess you transcend human nature with the subhuman and the superhuman. Well, I think in the first case, you say, well, you don't want to deny that there's moral improvement in the world, that maybe we learned things, just as we have accumulation of knowledge in mathematics or physics, that, after a while we learn, for example, one of those first principles of moral judgment, that we don't hold people blameworthy or responsible for acts they were powerless to effect. We don't have to rethink that one. Now the question, what else emerges from it? I pointed out, for example, that Lyman Trumbull, the senator from Illinois, as he was managing the 14th Amendment in the aftermath of the Civil War, insisted that there was nothing in that amendment that would challenge those laws in Illinois as well as Virginia that barred marriage across racial lines. Now we'd say it's no knock on Lyman Trumbull that he couldn't see all of the implications that flowed from his own principles. In fact, you can say that the life of moral experience is a life in which we're persistently discovering implications of our own principles that heretofore have gone unnoticed or unseen. But all of this takes place within the framework of a human nature that's probably has the same limits. And if you ask, 100 years from now, will human beings still have the corruptions of self-love, of dishonesty, that we don't need to lock our doors when we leave our houses, that people won't have conflicts of interests? I think we bet in certain critical respects on a human nature that is mainly unchanging in its most essential attributes. Wouldn't you?
And one of those essential attributes being its imperfection. I mean, it may be that certain things can be, perfected, or we can move towards perfection, but never get there. In which case,
right.
You're left being a limited being, as opposed to a perfect being.
Right.
Well, now, but speaking of your example, it is possible that principles can be declared which the long-term consequences of which are not clear, or at least not clear to some people.
Sure.
Right. It's also the case that you can dissemble some of those long-term consequences if you think they are too hot too hot a potato for contemporaries to handle.
I see what you.
Is that possible? I mean,
well, you may not disclose at once all of the implications that you
Yes.
see. I think what you have in mind is Lincoln saying, "I am not now and have ever been in favor of blacks voting in Illinois." It doesn't mean he may not be. It doesn't mean that that there is any principal barrier to blacks voting.
Right.
And if you concede the main premise that all men are created equal covers black people, that they too have a right not to be governed without their consent, and the same principle should cover voting. And I think what Lincoln understood was that once you plant the principle, that the implications will flow. The people, when they act upon the principle, there's a certain dynamic, you might say, that may be set off
Yes.
by people
That's right.
absorbing that principle.
Because the same issue comes up with segregation in schools. One can, if you look at the debates over the 14th Amendment, it's a mixed bag. It's not perfectly clear that the 14th Amendment forbid discrimination based on race in public schools.
That's right. That's
despite, and you know, the Brown v. Board of Education decision in 1954 found that in fact, that the 14th Amendment was opaque on the question. They couldn't make sense of it one way or the other. But it doesn't necessarily follow that the principle is not there, but that the implementation of that principle in 1896 might reasonably be different from its implementation in 1954, right?
Right.
I mean, it could be that segregation, if you're beginning from a bottom line where I suppose, I wouldn't want to lean on this argument too much, but it's possible, certainly, that if you're beginning from a standpoint where there are no public schools for blacks, then a separate but equal public school system for blacks is a step forward, a step towards equality. But in 1950 or 1960, a separate system for blacks could be the opposite of that. I mean, it could be circumstantially and intended to be a cap, a restraint on their equality and their achievement. Circumstances do make a difference in applying natural law.
Oh, right.
Don't
you
they?
mean a question? No, I'm just thinking of, no, there's a couple of paths I was thinking of leading off from there. But,
Go ahead.
No, it may be a matter of just how you think what you think your public could bear, whether you've gone along step by step. Because, you know, the court never did articulate the principle in Brown versus Board. All it said is that we think that the separation of children on the basis of race in the schools would have an impairing effect on the capacity of black children to live. There's no evidence there, in fact, that the segregation had that effect on the children in those schools in Topeka and so on. There was one of the late trustees of Amherst, Bill Hasty, had joined his cousin, Charles Hamilton Houston, in the NAACP scheme of litigation. And remember, the NAACP strategy here was to say that segregation has an unequal effect in different cases. In other words, that the wrong was contingent upon its effects in the school. And so we'd say to that, if we separate the kids on the basis of race and the reading scores go up, does the segregation cease to be wrong? All we'd say is it wrong in principle. That it'd be wrong even if the scores did go up. Well, the court never did articulate that principle, but the curious thing is that, you know, people throughout the country were kind of course, if they did articulate the principle, if they told us why it was wrong to draw any interesting inferences, moral inferences about the worth of people, their goodness or badness, whether they're people who deserve to be welcomed or shunned, whether they deserve benefits or disabilities, simply on the basis of their race, then we'd know what was wrong with policies of racial preferences, of assigning benefits and disabilities. Articulating the principle would have made a difference. But I remember Phil Curl at the University of Chicago maybe raising the question, well, how did you get from segregation in the swimming pool, in schools, to segregation in swimming pools? Are you saying that by being barred from the swimming pool, you're going to be barred you're going to have your capacity to learn impaired? Obviously, there was a principle that ran well beyond it. Now, but you bring us back, though. I saw the other direction. You bring us back to a classic problem of the law's teaching. Because when that issue, the Civil Rights Act of 1964 was before, remember the act that barred racial discrimination in private businesses that were open to transactions with the public. This is a major step. When that thing was being argued circa 1964, you found a very striking division in the country, with about 3/4 of the population in the North in support of that act, and about 3/4 of the population, as I recall it, in the South, in the surveys, in opposition to it. Now, 3 years later, between 1963 and 1966, there was a shift of opinion in which now 3/4 of the population, both in the North and the South, were in favor of that law. That is, 3/4 of the population seemed to have absorbed the understanding that it was wrong. Well, of course, this is the classic question. It was, how does the polity, how did the political order teach? And the argument was, it teaches through the laws, that when you say made segregation or discrimination on the basis of race are wrong, and you swept away, say, the private freedom to engage in that discrimination, you're saying, the law is saying in a very powerful way, this is not something we regard any longer as a matter merely of taste, that we regard this as a matter of moral consequence.
That's right.
And therefore it's something that should be universally applied. So, you're right, it brings us to the point of the law teaching. But at the same time, what you're touching on was the fact that remember Aquinas' line that the purpose of the law is to bring people to a sense of virtue gradually, not
suddenly.
not
all at once. Yes.
Not suddenly.
Right.
That people may have to be brought along, and people have to accept the first steps. Remember Lincoln's, is part. He said, nominated in the bond of the Constitution was the Fugitive Slave Clause.
That's right.
The obligation to return fugitive slaves. Right. And it was
something
done.
he defended strenuously. Yeah.
As the dry legal obligation, but also we would not have had this union that put constraints on the expansion of slavery and looked toward, as he said, its ultimate extinction. That was the original. So we could make it. It's a recognition that sometimes the people will not bear the full, weight of these principles. That at times statesmen may have to make an accommodation with an evil for the sake of compressing it. And as Lincoln would point out, the compression here, the art of compressing was that we put limits on it to be a block on the import of slaves from abroad, a block on the expansion of slavery within the country to the West. And as Lincoln would say, all of the language about this in the Constitution would be covert. Persons held to labor under the service of each state, And also, as Justice Curtis would later say in the Dred Scott decision, that told us that persons held to labor, that slavery was not in accord with the natural law. It could subsist in any place only by the positive law. By the positive law, making an accommodation with an evil for the sake of compressing it.
These days, most liberal law professors hew to some version or another of the living constitution theory, or what they call a living constitution, which sounds like it would be natural, a form of natural law reasoning.
Oh, it's organic.
Because the Constitution is some sort of organic whole that's constantly mutating and adjusting and so forth. But it isn't. I mean, they're very keen not to admit nature in any regulating sense or moral sense into the equation. Is there a place for natural law in jurisprudence these days, given the dominance of the left and of living constitution models?
Well, no, this is really curious because you find people like even conservative judges, like Scalia, my defense, Anthony Scalia, and Robert Bork, who profess up and down that it can't be done, that you can't do a jurisprudence of natural law by persistently giving us elegant examples of how it may be done. People, no, but people
Speaking prose all their lives.
speaking prose all their lives, that line review. But you know, people are always backing into the assumption of the recognition of the difference. For example, we understand that a visitor comes off a plane in New York from London. We know we don't have to look at his passport before we protect him from an unjustified assault in the street. We don't think that his claim, his right to that protection, would hinge on his citizenship. But we understand that the same man can't take himself over to the City College of New York that day and expect to be enrolled at that subsidized rate of tuition that the people of New York make available to citizens of New York. Right? Now, in the old days,
I'm not clear that we're.
I'm not clear
that liberalism is that clear on that distinction, but nonetheless, go ahead. Certainly in California, it's an open question.
You mean that the horse may apply for the...
No, but
well,
illegal status by itself is no bar to state benefits.
Okay, that's another expression of the problem, because you've had demonstrations over illegal aliens and their claim of a right to be citizens, and if there's a right here, it obviously couldn't flow to them through their citizenship because they were not citizens. No, so they must be invoking some principles of right and wrong that don't depend on the positive law, the law that is posited or enacted in a certain place. So, you know, in the past...
Whether they're right or wrong.
Whether they're right or wrong, the logic...
The logic points to something unwritten or non-positive, let's say natural law or something like that.
What comes into play is the first law of practical reasoning by Aquinas, that the good is that which should be done. The bad is that which should be discouraged. No matter how people, even the people who deny their moral truths, will have their own judgments on the things that are right or wrong. Like those people who insist there are moral truths, they are wrong, right? And they are casting. It's wrong to cast judgments. We can cast judgments only on those who cast judgments. Now, remember, Lincoln said that expressing the same logic, remember, that if slavery were right, then all words against it would be wrong and could rightly be swept away. And therefore, if I conceded it was right, I could concede that, you know, you should have the power to censor the federal mails to remove the abolitionist literature. Well, now we put in same-sex marriage in Massachusetts, and people are convinced of its utter rightness. And if it is right, then it should be taught that youngsters in the schools should learn a new kind of law, a new regime of laws that encompasses the possibility of same-sex marriage.
That does follow, doesn't it?
That's right, and we should discourage and reproach those people who would call it into question, perhaps even consider opposition, vocal opposition, to be a form of hate speech. So the moral logic remains. And the same moral logic that's engaged in with natural. So people recognize the difference between a natural understanding and the positive. The law simply. Most people will understand that simply because something has been enacted with the vote of a majority, that doesn't make it right. So they must have some principles in mind of right and wrong by which they test this thing. Now, the problem for the liberal side in our politics is that they are invoking principles, they're invoking high sentiments for the sake of overturning laws that are made by majorities, by the supported by public opinion, enacted by majorities. Those laws that say protect nascent children in the womb, confine marriage to one man and one woman. But the difference on the liberal side these days is that they will not recognize that there are moral truths out there. Moral truths that would hold their truth even when they run counter to the judgments of majorities. So Professor Tribe at Harvard will simply say, these are convictions powerfully held. And Professor Dworkin will say that these deep principles simply are in accord with our political tradition. Well, the same formula, the same formulas, Charles, could have encompassed the defense of slavery in this country. Right?
But so how do they get away with that?
By simply, my late colleague Earl Latham, when he was teaching at Harvard, starting to teach at Harvard, was asked his professor, "What do we do if we get a question we can't ask?" And he said, "Dispose of it. Dispose of it." How do they get past this contradiction? Dispose of it. Not notice. Don't stop to explain or to apologize, just get on with it. Understand is, we take as those moral truths those truths that are thought sensible by the sensible people. How do we know who they are? People like us. Right?
Yes.
So within our circles, we cultivate this understanding within the best schools of this country. We have an understanding what is progressive, as you said, and what is reactionary.
And then does that create the perverse incentive to populate schools, colleges, universities, departments, only with the like-minded, on the grounds that if your theory of truth is we all agree on this, yeah, we all agree that there are no truths, or that at least that there are no permanent moral truths rooted in nature. And if you had too many dissenting colleagues, this would be a contradiction of your theory of truth.
Life would be too unsettling. But I think it passes beyond a conscious attempt to do it. They're no longer even aware that they're doing it. Mm-hmm. So remember, we were trying to bring in some people at the college, my college, to preserve the teaching about the American founding. This ought to be somewhere in the curriculum of the college. And people were getting up saying, are you going to have an ideological litmus test for this? Well, look at programs on women and gender studies. It is persistent. As a point of orthodoxy, one has to reject moral truths and the notion of a nature that clearly separates, that distinguishes men and women.
Yes.
You know, and in fact,
there are never any anti-feminists in the women's studies program.
Of course. And I said, wait a minute, are the departments of sociology, women gender studies, are they just churning with deep arguments about abortion and same-sex marriage? And no, it's not that. All sensible. No, these are just sensible people who hold views that we haven't encountered anybody who holds any different views. Those are the people who are drawn to the profession. So it goes beyond even the recognition that we are consciously screening out those views that run counter to our own.
And that is a very grim picture of American education. I mean, that it has reached a philosophical dead end, as it were, and they're not conscious of that fact. Or if they are conscious, they are resigned to it in some way. Is there from 45 years of experience at Amherst, is there any causes of optimism that first principles of morals and reasoning can outlive the modern university?
Well, I began there when I was a little boy. I think the soft spot in my head was just hardened at that point. It was no. I'm not optimistic about the established schools like Amherst and Wesleyan and Brown and so on. It seems to me that they're in a kind of terminal condition about this state of affairs. I think. But look, these new places sprung up. Here's Thomas Aquinas College in Ojai, California. That's out there 40 years now. Right. People forget you could get this thing going in a short space. The University of Chicago, what came from in the 1890s, and in a short while you had a great university built. And my own sense is it's going to require the founding of some different universities. I think some of these universities and colleges are living on their reputations. And the curious thing is the state of some alumni who have this nostalgia for the place they knew in the 50s and early 60s. They look at the scene through rose-colored glasses, as we say, and it's the place that where they grew up.
Yes.
And they have a certain affection for that.
And the football team, which they follow.
Oh, that's very important. And of course, the football players are the people most anchored in. they are the people who are
athletes in general. Yeah.
Oh no, they
are fairly well anchored.
Yeah, that's right. No, for them there is an up and down.
That's right.
There is a moral up and down, and there is a code, and there's a
good and bad.
That's good and bad, and they have a sense of what happens when people are not holding up their own end, not doing their work, right? But these are people who tend to sort of see around corners and see through spurious schemes. Mm-hmm. I'm rather bleak about. But look, as my friend Dan Robinson argues, look, we have in our experience the experience of conversion. We know conversions take place. Lincoln understood that institutions can be corrupted, polities can be corrupted, a republic can turn into something else. When the individuals who compose those institutions can be corrupted. But in the same way, conversions come along. And if they come along for persons, they can come along for the persons who fill those institutions and found new ones. So I think our capacity for regeneration will always be there.
Yes, but there's conversion, but there's also habit. And as Aristotle says, habit is really the key to moral virtue. That's
right.
It's self-reinforcing, and that's the part of the problem in the universities.
I've heard this lament from a member of the trustees. The students are happy. The faculty seems contented.
Right.
Why do you want us to pick a fight with the faculty?
That's right. The endowment is up.
The endowment is up. So what? Well, a friend I know went to visit the chairman of a board of trustees of a notable establishment. I won't tell you which one. And he came back and he said, it was as though I visited the chief executive of a pharmaceutical firm who told me that he is interested in the public relations, the public outreach of his institution, but he's not overly interested in drugs. You know? And he said, I'm just dealing with the fundraising and the external relations of but not especially interested in the substance of what is taught, you see. And I find curious the tendency we're seeing of late in presidential searches for these places to look for something called administrative experience while not paying very much attention to the writings of these people. To say, are you saying that the understandings that someone is articulating in the writing carefully done and crafted bears no interest in an academic place, just in the question of what is it you're looking for when you're looking to fill the spot of an educational leader, that you're not interested, you start with the assumption that the writings are irrelevant and that it's not even worth reading the writings of these people.
Yes.
And what a curious notion to take hold among those so-called worldly men and women who now function as trustees of these places.
That's right, but in part that's a byproduct of specialization in the academy, isn't it?
No, I think it's our friend Michael Ullman has a different take on this, that often people in business feel kind of diffident and bashful, especially when set against academics who are really the disinterested intellectuals who made the life of the mind their vocation, and they are just men of business tending to the prosaic affairs of making a product that people need and want, and making a living. And they I've seen this in past that members of the trustees are a little diffident about defending themselves in front of the faculty, and you wonder what happens to these accomplished men of business when they join the board of trustees, and they suddenly become sort of tools that just moved around to suit the administration or the faculty. In fact, I used to like the fact that I lived in a mixed regime. I may not agree with my colleagues, but it's nice that my colleagues did not control everything, that there are other sources, that there are people connected to a wider world who have some voice in this matter, that it was mixed in a very
Your colleagues in the
way.
faculty, you mean, don't have total authority over you. You have trustees, you have
trustees, or
the president and the administration.
There are people who are connected to alumni who knew the place in the past, who carry the traditions of the past, know how things were done perhaps better in the past, appreciate how they may be done better now, but bring a wider measure of the record of the place to bear on these decisions.
Sure.
You know.
But your point is you don't live in a mixed regime anymore.
Not anymore. Somehow the notion has taken hold that the faculties are sovereign. You know, they don't own the place. The trustees, after all, are the legal authorities.
Well, as you and I were talking before, Bill Buckley wrote God, a Man at Yale, published in 1951, complaining that faculties thought they owned the university and ran it, and he called upon trustees and alumni to take back the university from these left-wing faculties. And that has never happened. I don't know of a single instance where that's been successful.
Even when prominent businessmen come onto
Yes,
the board and they dissolve, you know.
You would think their self-confidence, and even just alumni self-confidence and pride would assert itself. But when it does in a very weakened and sort of tangential way.
Right. But you know, this feeds back into your original question, though, Charles, about skepticism that's taken over. You know,
Yes.
you talk about the movement for the living constitution, the organic metaphor. Woodrow Wilson liked this, and Woodrow Wilson complained that the founders were pre-Darwinian. They didn't understand that there was no telos, no purpose contained in human nature. Well, the classic understanding, you know, in Aristotle is, you know, look like this. If I understand what this thing is, I understand its telos. I understand its purpose. I understand the purpose for which it's made. I also understand the difference between one that works well and badly.
Sure.
Now, if I take that biped who conjugates verbs, unless he's living in China, that biped who conjugates verbs, I say, there's something about his nature that destines him for political life, right? He said, well, that means there was a fixed nature of human beings, and therefore we used to say there was a telos. We knew the difference between a good man and a bad man. We knew the difference between a polis, which in its laws were teaching uprightness, an upright life, which did justice, which protected the innocent, you know, restrained the vicious. But now what that understanding is, no, that was, it's implausible to believe, as Woodrow Wilson thought, that the founders had in hand truths about the nature of human beings and the nature of rights that would hold across the epochs, right? What they didn't understand, it's another version of relativism, that we know these moral truths only within the historical epoch in which they're held. Though that proposition itself will be true across,
Yes,
if they pick up your line. So you treat it as utterly implausible that there is a fixed nature of human beings that implies a telos, a purpose, a moral purpose. The moral purposes are not stable because that nature is not stable, and we're no longer convinced they're moral truths because we change our minds on these things, notably from one generation to the next. So if there are no telos, we don't know also where it's tending. That's the progressive evolution. And you've been eloquent on this one. I'm the leader, but I don't know where I'm leading. You know, I've got to be with my people, maybe leading from behind, seeing where they're going. But we're not clear on the end. I guess it's Hegelian. The purpose will reveal itself as the owl of Minerva spreads her wings at the end of time, and we'll find out what it's all been about.
Yes, but the problem with the modern university, I think you agree with me in this, is less its skepticism in a way. I mean, it is professionally skeptical, and it is
but utterly convinced about a dogmatic
skeptical.
relativism. Right.
That's really, and the problem is its utter dogmatism on behalf of its partial skepticism, but only partial skepticism, because they're not skeptical about their own dogmatism, essentially.
Yeah, right.
Now, today on the right, among conservatives, many of whom are your friends,
My
of
friends.
course, they would share your disapproval of the modern university and of the living constitution jurisprudence that is at home in the law schools there. But they would still nonetheless part company with you on this question of whether natural law jurisprudence has some important role to play in interpreting the American Constitution and applying the American Constitution. So they're nervous, among other things, about, one of your books is called Beyond the Constitution.
Right.
That makes them nervous. Because if you're free to go, if a judge is free in his reasonings to go beyond the Constitution, they fear, beyond the positive law, there's just a neverland out there of personal theories and progressive preferences to draw upon. And maybe there's a little natural law out there someplace.
There's a moral sense
But,
contained there somewhere.
but
huh?
there's an awful lot of nonsense out there too. So why are they wrong to be afraid of natural law reasoning as you recommend it?
Thanks for giving me the lead in with Beyond the Constitution. That may be perhaps the beginning of an answer to this question, because the pitch in that book was that as we try to apply the Constitution to the practical cases that come before us, we're persistently led out of the text of the Constitution to those principles of judgment that were never contained fully in the Constitution, which could not be. So, for example, if I am restrained by the fire department, say, from walking to my apartment because one day they're fighting a fire in the street and they're blocking off traffic for a moment. Well, my liberty has been constrained, but I don't think my rights have been denied, and my natural rights have not been abridged. We say your liberty has been restricted with justification. I run into a youngster on Connecticut Avenue in Washington about to go into a subway with a bike. I said, really, you could do that? He said, yes, but not during rush hour. And he understood why that was reasonable. He understood that, yes, his liberty was being restrained, but for good reason. Now, if you look at the Constitution, it's unreasonable searches and seizures we're after. At every moment, in applying the Constitution, our judgments will turn on our understanding about the ends and the purposes that are justified or unjustified. You know, in the original argument about the Bill of Rights, people were saying, well, why don't you specify my right to get up in the morning, my right to walk down the street, my right to wear a hat?
To travel, to marry, to...
No, so my point is, you could as plausibly add to the Constitution my right not to be searched unreasonably at the airport, my right not to have my car stopped and my trunk investigated unreasonably, and the judgment you could enlarge the inventory of those places where your rights could be endangered or violated.
Absolutely.
But without touching the thing that is really critical, the principles of justification by which you're measuring the justification for restricting these freedoms. Now, our friends on the conservative side, they are recoiling. I think they are being led to skepticism, but first they're recoiling from what they see as judges soaring off, removing themselves from any connection to the text of the Constitution, expressing high-minded sentiments, which happen to coincide with the liberal agenda, and creating new rights that suit it, and doing it in the name of a higher law. And so what they do is recoil from any attempt to invoke those sentiments. But part of the answer to them is, look, if you think you can see a liberal activism that is wrong, moves to detach yourself from the Constitution, reasoning that is wrong, well, why don't you simply get clear on the difference between a plausible plausible invocation of natural law and an abuse of natural law, and get clear on that one. Right.
So, I mean, Justice Scalia would not say, would not deny that there is a difference between an unreasonable search and seizure and a reasonable one, and that the judge may have to decide in the case before him whether the search and seizure was reasonable or unreasonable.
Right.
But his point of denial is that requires natural law to determine that. Would that be correct? Isn't he saying something like, usage, previous cases, precedent, this language of the statute, maybe the intentions of the legislators who adopted it, what they said in the legislative history of it. That's enough. You don't need some airy-fairy thing high above the text of the Constitution.
Let me recall some points I made to him in this respect. I just mentioned Lyman Trumbull and telling his colleagues up and down that nothing in that 14th Amendment was going to challenge those laws on miscegenation of the states. And I put the question to my friend Scalia, therefore, would you not have, if that's the original understanding, it's quite clear that the 14th Amendment probably wouldn't have had a ghost of a chance of passing if Trumbull could not have offered those assurances to his colleagues and the public. Now, if we're guided by original understanding, the question was, should the court not have struck down those laws in Virginia that barred marriage across racial lines? Well, if you're going to do that, you can't invoke the text. It's not in the text, and it's not in the original understanding. So you're going to have to explain. You're going to have to explain in some way why differences in race will not bear with any aptness or relevance on the question of your fitness to accept the obligations of marriage. Now, I put the question to him in the Second Amendment case, in the Heller case that he wrote just a few years ago. He invoked
District of Columbia.
District of Columbia. Yes, that was the District of Columbia. Right, right. Because then the question was, are you going to extend that from the District of Columbia to the states?
Right.
Okay. He invoked a right of self-preservation, which would supply the ground for the access to a gun, weapons. And
for individuals.
That's right. That's for individuals, not merely for militias. And I said, I had a conversation with him. I said, I assumed you were invoking the right of an innocent person to fend off an unjustified assault. Right. I said, well, of course, those words are nowhere in the Second Amendment. So the question is, were you appealing to a deep principle that did not depend for its validity on being mentioned in the text? Or were you saying that James Wilson, one of our founders, Blackstone, the great English commentator, had said it, and many people read them at the time? Now, I think he's tilting to the second one. And the danger there is that our friends doing that version of conservative jurisprudence will turn jurisprudence into legislative history. We have to find out how many of the people who voted for the Second Amendment and who voted to ratify it had read Blackstone, had absorbed Blackstone's understanding as their own. And even if we get the answer to that question, which I don't think we can, it doesn't give us the answer to the question we're asking, which is there a deep principle that would tell us why a person could be justified in having access to a lethal weapon as the only means of defending himself, a deep principle that the Constitution should not be able to forbid? Okay, so I think...
Has he invoked the Fifth Amendment? I mean, not just in both senses of not wanting to incriminate himself, but also in the sense of, since the Fifth Amendment does say that you can't deprive someone of life, liberty, or property without due process of law, that there is the Constitution itself recognizes some right to life, which inheres in the individual.
Now the question is, do you think that individual
whether you need a gun or not to back it up is the question.
Okay, but the question further is, do you think that if they had neglected to put that Fifth Amendment in, that we could not have understood that right to be there? Right. See? Now, take the assisted suicide case in Oregon, the Oregon case of a few years back, and where the court was approving the use of drugs for assisting suicide. And Scalia was in opposition, and he simply invoked an old tradition, Hippocratic tradition, that it cannot be the purpose of medicine, cannot be the purpose of a doctor to secure the death of the patient. That's not his purpose. His purpose is to restore and preserve the patient. Right. Now, Justice Kennedy heard that and said, yes, that's one traditional view of medicine. And Scalia just went up like a Minuteman III, as we used to say. What do you mean, one traditional view? Now, in order to explain that argument, you'd have to invoke some notion of natural law, about the rightness of that deep premise of life, that people step off a curb and they look both ways. They want to preserve their lives. We have drives at the colleges to get food, to relieve famine abroad. It's impossible to imagine an ambulance constituted on the premise that our job is to get to the victim and make sure we dispatch him before his relatives have any tough decision. Right. It's impossible to dislodge that premise about the priority of life. But you'd have to make some kind of an argument of that kind. And when you're doing that, you are appealing to those deep principles that are not always contained in the text. And the founders didn't think they really had to do that. They assumed that the kind of a world of moral judgment and a tradition of moral judgment was in place, that people were cultivating the sense of being informed by the classic books and the biblical teaching.
Now, in Beyond the Constitution and in many other of your writings, you lean for some support for this argument on the Declaration of Independence as a document which is not in the Constitution or part of the Constitution per se, but which informs it, and which does, in written words, invoke abstract principles. Unalienable rights to life, liberty, the pursuit of happiness, and so forth, the laws of nature and of nature's God. And I wonder whether, does it allay conservative anxiety or not that you can point to a document which is a kind of legislative history to it, and it precedes the Constitution and helps to explain maybe the Constitution. You'd think that would be...
No, it doesn't.
That would be some explanatory help in determining the meaning of,
it turns
these things.
It turns out not.
Yes.
That among many conservative jurists, they'll say, that's just...
What?
That's just sentiment. It's no part of the laws of the United States. And yes, it's part of the organic law of it. Now remember, as you know, you've said often, that when Lincoln at Gettysburg said, 77 years ago, our fathers brought forth this new nation. If you count back 87 years from Gettysburg in 1863, you end up at 1776, not at 1787, 88, 89, with the origin of the second Constitution. So as Lincoln understood, the Union, the regime, began with the articulation of that first principle that articulated the character of this regime. And he said, from that proposition, everything else radiates. And the function, what is a constitution? The purpose of a constitution then is to get a practical structure of governance that can produce a weave of experience that is consistent with that underlying. The first constitution didn't do that. It's the second one. I mean, as Justice...
the Articles of Confederation.
Right.
Yeah.
As Justice Sutherland pointed out, the Constitution was made to secure a more perfect union. The Union existed before the Constitution, right? And so we point out, people, look, why do we assume that we had to make a Constitution that something in the principles of the American regime demanded that it be a rule of law, a government by consent rather than despotism? How do you account for that? So it provides the guidance, it provides the underlying principles. Didn't get everything right, It sort of scored the British for being so ungentlemanly as to raise a tumult among the slaves to sort of rouse them. But it laid the premises, it laid the principles.
We took that part out, though.
Well, but no,
There's a remnant
of it there. Yes.
But they did take out the long attack upon the king.
Right. So, but among the conservatives, there was just dubiety about it. And when we tell them, we point out to people that you're doing this all the time. You are making this move to these underlying principles that are so deep and so evident. Like, we don't hold people blameworthy for. Well, for example, I remember one lawyer years ago was arguing before the Supreme Court, and Scalia was bearing down on him. And he said, Mr. Justice, I want to retreat to my constitutional right to be presumed innocent till proven guilty. Oh? Is that in the Constitution somewhere? I don't know. I can't find my copy of the Constitution, presumed innocent. And yet, he's utterly convinced that is a deep principle of the rule of law, treating like cases in a like manner, even if there were no written constitution. The one I've cited on this, I thought the most elegant example was that one by John Marshall in that case, classic case of Fletcher versus Peck, and was it 1810 or 1812, where you had the bribery in the legislature, corruption and granting of lands. A subsequent legislature sought to undo the grant, but there are many independent, innocent buyers. Now, Marshall could argue that abrogating a grant in this way was equivalent of destroying a contract, impairing the obligation of contracts. And he could have settled this simply by invoking Article 1, Section 10 of the Constitution, laws impairing, in the states, impairing the obligation of contract. But instead of doing that, he did something far more elegant. He tried to show how the Contracts Clause in the Constitution could be drawn deductively with the force of a syllogism from that deeper underlying principle of ex post facto laws, of making something punishable, wrongful after the fact that was not punishable when it was done. And as Justice Johnson said is his concurring opinion, I'm not invoking the Constitution, I'm invoking a principle that would give the law even to the deity. Even God may not rightly, deny the ex post facto law. But then Marx would say, Georgia is a great state. It is part of this empire. But this law would still be wrong if Georgia were a separate state, outside the Union, outside the coverage of Article 1, Section 10, because the wrongness of this law was based on a proposition whose validity would not depend in the least on its mentioned in the text. And see, one of the great, I think, achievements of Marshall in that first generation was that, in a way, they're trying to show that those things that we regard as the fundamental law, the deep law of the Constitution, are fundamental precisely because they depend on understandings that do not themselves depend on the mention in the text of the Constitution. Yeah.
Now, but according to the Declaration of Independence, one of the things that the natural law points to is that the just powers of government have to be derived from the consent of the governed, right?
Right.
Which means they get to vote, they get to make their law, their constitution, and their statute law in some way or another, as they wish to within certain limits. Now,
right.
So natural law is a great thing, but you need human law. You need positive law. You need a constitution and statutes and so forth.
That was part of the whole tradition of natural law.
I just want to ask about that because in a recent article by you in the Claremont Review of Books.
A great journal.
Thank you.
With an inspired, accomplished editor.
In the 10th anniversary issue, a piece called The Mirage of Enumerated Powers.
Right.
You argue that the attempt to find a clear and definitive theory of federalism or an assignment of functions, some to the national government, some to the state governments, is illusory. Mm-hmm. And thus, though in Article 1, Section 8 there is an enumeration of powers, it's pretty unreliable, it seems, as a limit on government.
Right.
Now, but isn't that a very dangerous admission in a way? I mean, doesn't that undermine the moral, not to mention the legal authority of the Constitution as such? And this is, of course, one of the things that conservatives dislike about your reasoning along these lines. It does seem, if you call enumerated powers a mirage, you are not only suggesting that they can't be legally, they can't give a lot of legal guidance to judges, but also that they're, as a principle of limited government, they seem to be illusory. They seem to be unreliable. And that weakens reverence for the Constitution, doesn't it? I mean, to suggest that that something that would, at least in our past, have been taught as one of the primary principles of structuring American politics, namely federalism and limited delegated national powers, that's illusory. It's not there. It's a mirage.
Right. I think I invoked my.
So why are you running down the Constitution, Professor Arkes?
No, the argument there was that this attempt to fence off the thing. It's at best prudential distinctions, but they cave in. My late Professor Morton Graz at the University of Chicago said it was a great defender of federalism. He used to say that if functions were allotted in this system according to some degrees of naturalness, the local governments may be left with nothing to do. When people licensed to teach in Massachusetts are creating illiterates in Iowa, or licensed in one place are creating accidents in another place, you could just as readily have down the road, not the Massachusetts Department of Motor Vehicles, but the national. But I thought I pointed out that John Marshall lifted the curtain a bit on this when he in the old Dartmouth College case, when he said, if we had a law in the state that dissolved a marriage without the consent of the contracting parties, that could present an interesting question under the Contracts Clause. But fortunately, that question isn't presented, so we don't have to reach it here. Yes. But what he raised the curtain in this way. We see that nothing was thought to be more redolent of local law than law on marriage and the family. But it's entirely possible that something in those arrangements could run afoul of the principles of the Constitution, as with, of course, barring marriage across racial lines. As soon as we think that is inconsistent with the Constitution, suddenly the federal government federal courts can cover that question. For years, we found even liberal judges in cases of mixed racial marriage, the dissolution of those marriages, assigning custody of children, tending to prefer the white parent because they've tend to absorb the sense that to be a part of a black family is to be part of a family that's probably freighted with disadvantages. But on the basis of color, people were removing custody of children. Well, suddenly that is challenged in a federal court. Now, I was invoking an old understanding of John Marshall that any question that arises under the Constitution or the laws of the United States must be able to come within the reach of the judiciary. But there's a corollary to that, and that is if the judiciary can articulate new rights under the Constitution, like a right to abortion, the legislative branch must be able to vindicate the same rights on the same part of the Constitution where the courts find it, and in filling them out, marking their limits. The one thing that should not be tenable under this Constitution is that the court can articulate new rights and then assign to itself a monopoly of the legislative power in shaping those rights, so that if it's possible now that federal courts can tell us that it is wrongful to assign custody of children in a racial way, it's not inconceivable that the Congress may be legislating on the same subject. Now, these kinds of things sort of dissolve. Hamilton is one last point. Hamilton, I think it was the Federalist 3233, said there are two subjects which it's utterly unimaginable the national government can ever reach. One, the matter of this inheritance and descent, and the second, the matter of taxes on land. Well, both are within the reach of federal courts now. The state of Idaho arranges the rule of the administration of an estate of youngsters by assigning the preference to the father, to the male, and that's struck down as discrimination based on gender. And with taxes on land are always challenged as a basis for funding schools because of the inegalitarian implications. So my point is, Charles, there's nothing you can name so prosaic, so local, that could not conceivably run afoul of deep principles of the Constitution and suddenly become the business
or at least of the amended Constitution. I mean, you're counting the 13th, 14th, 15th Amendments, which do somewhat change the nature of federalism and the disposition of certain powers, right?
No, Justice Harlan in the famous Plessy case thought that the wrong of racial discrimination could be drawn, as many people at the argument of the 14th Amendment thought, could be drawn from the Guarantee Clause, from the guarantee of Republican form. That he didn't need the Civil War amendments. It's contained in the very principles of Republican government. And that argument was heard.
He did lean on the 13th and 14th.
Yeah, but it wasn't clear. He spoke about the liberty of persons rather than the actions of states. So it could have been meaning the 13th Amendment, which didn't talk about the actions of states. But at the end, it was the Guarantee Clause. He could just use the original thing. But what I was arguing in the book is that, of course, there are moral limits to it. In fact, that's the most critical point, that the hard limits to the reach of the government are the moral limits. And we have a number of them over the years that judges have articulating the principle, like the Contract Clause itself. and we'd say, on what basis did President Obama overturn the claims of the bondholders of Chrysler? What's the ground of law which the government began to engage itself in this in the auto industry? And there are very clear inhibitions anchored in deep rules about the government going into business. That the government makes the moral rules governing commerce if it cannot be a player under those rules, because it will be tempted then to tilt the rules to govern those investments made by the government. Or one of my favorites, of course, is the
Welcome to Beijing.
Beijing. Exactly. But Justice Story, in that famous line, what you may not do directly, you may not do indirectly. If it's wrong for you to kill Jones, it's wrong for you to hire someone to kill Jones. And if the federal government, take the old Butler case from 1936, if the federal government does not have the authority to establish the wages at the Hoosac Mills in North Adams, Massachusetts, it may not do it indirectly by raising the taxes on those mills and remitting the taxes if they'll simply accept the federal rules. So Justice Roberts said rightly, they were asking us to buy back our freedom. Well, what I was trying to point out is that we have some serious principles that are very firm in their borders, firmer than the lines that separate federal and local jurisdiction. And that if we would, that when Hamilton spoke of a limited government, he meant moral limits. He meant a government that simply cannot be constituted to do just anything it wished. As a moral agent, any person we call a moral agent who can reason over matters of right and wrong may work his way, we hope, to the understanding that he doesn't have, as Lincoln said, a right to do a wrong. That he doesn't have the right to rape and to murder, and that there are certain things he cannot claim the freedom or the right to do, even in the name of his autonomy and his freedom. Well, if you apply the same thing to remember Plato's line, that a person who with self-control has a constitutional ruler within himself. We don't say that a person with self-control is a weaker person, but a stronger person. And a government under self-control, a government that forgoes to itself the things it ought not do and may not do, is a government then that can concentrate its wit and its powers on those things rightful for it to do.
But a limited government is not just a government with moral limits, although it presupposes moral limits. I certainly would agree with you about that. It's also a government that has institutions and some kind of constitution, whether written or unwritten, in our case written. So that when Hamilton speaks about that, he's talking about the legislature. You can't presume that the legislature gets to interpret and apply its laws to itself, and that it's only legislative business whether or not a law is constitutional or not. No, the court has a proper role in determining whether or not statute law is squared with constitutional law or not. I mean, this is part of Hamilton's defense of judicial review, after all. But the larger point is that, yes, there are moral limits implicit in the Constitution, and some of them perhaps spelled out in it or in the Declaration of Independence, but also that there are institutions and the sense that the people are sovereign, and that their sovereignty has moral limits to it as well. But still, it's their constitution.
Right.
It's their law. And so, you know, if one could certainly argue that separation of powers is difficult to pin down in hard cases. But should one conclude from that separation of powers is a mirage? That enumerated powers are a mirage? What's left to limit government institutionally and in the public, in the confidence of the public mind, you could say, if everything resolves down to unwritten moral propositions or common moral propositions as they may be the most important limits on government ultimately, but are there not very important limits on government that are more proximate, that the people have confidence in or should have confidence in and need to have confidence in, I guess?
Well, I think one of the advantages, as I begin to see, of doing it the way I've sketched out, is that it relies on understandings that are accessible to ordinary people in their common sense. Let me just try this another way, inspired by what you've just said. Let's say I sought to limit the government by saying, the government should not enter into the auto business or computer business. And I get a whole list of things like that. I'm not sure that list would ever be complete. To me, well, then some people say, well, our video games like the computer business. You know, we get arguments of that kind. And we don't know
what about the satellite radio in the car?
Okay,
yes,
now, how about doing it that, let's say, one, doing it that way, as opposed to saying, invoking Justice Sutherland, saying, a government that can't not be clear on the difference between business and government, doesn't understand the difference between the two, that the agency that makes the moral rules cannot itself be a player under those rules, because if it starts picking winners and losers and investing in one firm rather than another, it's going to have its powerful temptation to tilt the rules, use tariffs and taxes. So it has to be detached. Someone has to make the rules about what is rightful commerce. Now, I think we're on more solid ground when we repair to those basic rules that ordinary people can understand them more readily, rather than understanding why this list of businesses, and is it income? Did you neglect to put in the interior decorating business and things of that sort? But the rules you mentioned just now, let's say the separation of powers. People are still learning about the implications of the separation of powers. The Democrats sought to finesse the impeachment of Bill Clinton by passing a resolution of censure. But if that's a resolution that has bite with a penalty and it names Bill Clinton, why, there's a bill of attainder, as we say. What is a bill of attainder, right? John Locke gave us the guide to this. The value of the separation of powers is that the people with the legislative power make this decision, and the enforcement is to put into diverse other hands. That is to say, when you legislate, it makes a profound difference that you understand that what you're laying down as law will not be in your hands to administer.
Of course.
That may be put in the hands of people who are not friendly to you, but hostile to you. So the caution is, you better make sure that you do not legislate something that you would not see applied with full force against yourself. The separation of powers then really contains a way of making operational what the philosophers would call the universalizability principle, or do unto others as you'd have done, or the categorical.
Or the equality principle.
Exactly, treating people under like rules. Well, I'd say but these things are not spelled out in the text of the Constitution. And even people there are people who are lawyers, who are making votes in Congress, not apparently recognizing that what they were doing to finesse the case of Bill Clinton really involved a deep, deep violation. Well, how would they understand that? They couldn't understand it simply by reading the text. They could understand it only by understanding the deep principles behind the text, just as the account you were just offering is not itself contained in the text of the Constitution.
Oh, no.
It was a fair commentary drawing out the logic of it. So what we're saying is, well, if that's where we have to go in reaching these decisions, let me be clear that that's exactly where we have to go, and that's what we have to do better and clarify in these matters.
We now brush up against an unwritten law that our time
is up.
Is up.
Really?
Thank you very much, Hadley, Arkes. Thank you, ladies and gentlemen.